Good morning and welcome back to the channel. First of all, thank you all so much for watching my previous videos on this subject matter and for signing the petition and sharing the petition and for following me on Twitter and Instagram. I'm really very grateful for all of that. So by popular request, I've decided to take a look at or at least one of the Elaine Bredehoft interviews that she's doing the rounds with, essentially drawing stark comparisons with the UK trials. So I've picked one of those from CBS. This is obviously going to be under fair dealings, copyright exemption. I'm linking the original video in the description below. I'm only using the bits that are necessary and I'm going to add legal commentary to it. So that's why it's under fair dealing for copyright exemption. So let's get into the interview and I'm going to give you my reactions as they were when I watched this interview.
Yeah, a major setback for women, for women inside the courtroom and outside the courtroom.
Because?
Because basically what this said, Amber had an enormous amount of evidence, although a lot of it was suppressed in this case as opposed to the UK.
Right, I'll pause there. There are two things to unpack there. First of all, she says that it's a major setback for women, and secondly, she says there was evidence in the UK trial that was not in the US trial. Now, I'm going to break those into two. First of all, I don't think it's a setback, let alone a major setback for women, because Amber was taken seriously. Her complaints were taken seriously. This was a 6-week trial with evidence, and it was heard with a jury. It was given all due full attention. It's just that the jury didn't believe her. So to say that it's a setback, basing it on what she goes on to say, or she will go on to say, of a lack of evidence, I find to be incredible, as in I don't find it credible, because there was a significant amount of evidence in the US trial, and I would suggest more so than the UK, but that is the second point that I come to. If you watch my previous video, you will have seen my comparison with the UK trial, where Amber Heard was a third party to that claim. If she's not a party to the claim, she is not subject to the same obligations of disclosure, what in the US is called discovery. Discovery and disclosure, for those that aren't familiar, is a process whereby all parties to a claim must go through this process of finding documents and finding evidence and anything that could support the other side or undermine your own case. You have to tell the other side that those documents exist. That is the disclosure process. Essentially, that's done by way of a spreadsheet, a list of documents that are available. And then we have what we call inspection. I trust there's something similar in the United States. Inspection is the other party saying, well, that's interesting. You have a recording of this conversation on this date at this place and this time. I would like to listen to that. We'd like a copy of that piece of evidence. Very often the inspection is just send it all to us. Give us all of the evidence. That might be the way it works in the United States. Perhaps some of my United States or Canadian or other international viewers can comment as to how it works for you. Certainly in the UK, in England and Wales, that is how it works. We have disclosure, then we have inspection. Inspection very often is just give us everything you've got. Or it might be, I'd like to look at these few things, but don't bog us down with everything else that you've got. Sometimes that's known as a strategy as burying your opponent with evidence, which means that you just get so much stuff that you don't know where to start. So that's why we have the disclosure process first. Now, drawing particular attention to Elaine's comments as to having evidence in the UK trial that there was not in the US trial, and saying that in essence, saying the UK trial was fairer because there was more evidence. Well, if you watched my previous video, and I'll reiterate it just here, I don't agree with that, because for the reasons that I've said, Amber was a third party to the claim. She was not subject to the same obligations for disclosure. In fact, Johnny Depp's lawyers made an application for third party disclosure, in other words, to get Amber to disclose material, and that application was refused. In other words, they wanted to see material that would help their case, Johnny Depp's case, and the judge refused. This was at paragraph 576 of the judgment, which I talked about extensively in my previous video. The judge even warned Johnny Depp that he would have taken legal advice as to the fact that Amber Heard was not a defendant, and in fact it was News Group newspapers and Dan Wootton that were the defendants, and that it was they that were subject to the disclosure obligations and not Amber Heard. In paragraph 576, The judge does say that Mr. Sherborne, for Mr. Depp, suggested that there was unfairness to Mr. Depp because his effective opponent was Amber Heard, and yet she was not a party. She had no obligation to make disclosure, and she provided information to the defendants at different times at her choice. In other words, she chose what evidence she gave, and at her choice. The judge goes on to say, I'm not persuaded that these comments carry any weight. So the judge was saying that I'm not persuaded that there's any weight in the fact that Amber Heard could essentially pick and choose the evidence that she gave to the defendants. The judge goes on to say that because she's not a party, she was not obliged to make disclosure. So for the benefit of my international viewers, and I really thank you for joining me, what this essentially means is she was not obliged to make the same disclosures as the defendants in the trial. So whilst Elaine is obviously alluding to the defendants leaning on her for evidence, that simply wasn't the case. The court could have ordered her to make such disclosures, and this is where the judge goes on in paragraph 576. He goes on to say, as a third party, the court can nonetheless order her to make disclosure, but only if quite stringent conditions are satisfied. The claimant, Johnny Depp, did indeed apply for such third-party disclosure against Amber Heard. His application was unsuccessful. And then goes on to warn him that he would have taken legal advice as to the fact that it's different defendants and there are consequences of Amber Heard not being under the same obligations for disclosure as these two defendants. So those are the first two bits that I take issue with from this interview. Let's listen on.
But look at all the women who have no evidence. All these women who suffer from domestic violence, domestic abuse, they don't have evidence. And basically what this jury said is unless you pull out your cell phone and you tape record your spouse beating you, you're out of luck.
So let's pause there for a moment again. She's right in that some people don't have evidence, and that is unfortunate, that is a shame, and that might result in an injustice if someone cannot prove a claim and they cannot prove allegations. However, then there is a double standard here. What Elaine says is if you don't take out your phone and make a recording of your spouse beating you, then you're essentially out of luck. But again, this is a double standard because, as I mentioned in my previous video, there was an audio recording, but it wasn't of Johnny Depp beating Amber Heard. It contained what sounded like, for legal reasons, Amber Heard admitting to beating Johnny Depp. However, the judge in the UK trial didn't apply any weight to these audio recordings. This, with all respect to the learned judge, is probably one of the most shocking findings that I found in this judgment at paragraph 175, because as a lawyer, as Elaine just said, if you have a recording that shows what happened, you should listen to it. And as I said in my previous video, I've had a case where there was a recording of the whole argument with aggression and violence within that conversation, which was in stark contrast to the evidence that was presented at court. The judge found the audio recording persuasive because it was a contemporaneous recording of precisely what happened. But in the UK trial, at paragraph 175, the judge says, in my view, no great weight is to be put on these alleged admissions by Miss Heard to aggressive violent behaviour. Whereas if we were to agree with Elaine in this interview, then weight should be placed on this recording. Because as she says, without these recordings, we won't know what happened. Let's listen on.
I think it was bigger than that because you had the evidence, as you say, but they did not believe her. Why do you think they did not believe her?
I think that a lot of that was that it was Johnny Depp. I think the celebrity status.
But she's a celebrity too.
So just pausing there, here Elaine essentially saying the jury didn't believe Amber Heard because he's a celebrity. But the natural response to that, of course, is that Amber Heard was a celebrity as well. But note that she doesn't say that they considered the evidence and everything else. And frankly, I do have faith in the justice system. It's not perfect and there are mistakes. But in this case, with a jury trial, I would offer up this as a thought process. In the United Kingdom, we do have juries and single judges making decisions on different cases. In criminal trials, we retain the jury. I believe that we retain the jury because we entrust that if we're going to punish somebody for something, send them to prison or fine them and so on, then we better be right. And what better way to be right than have a jury of your peers objectively consider all of the evidence, applying both the subjective and the objective tests whenever necessary, as directed by the judge in accordance with the law, but the jury as the finder of fact, because we entrust that no single person is going to be swayed and biased. No single person is going to upset the ultimate decision, because if that's the case, you get a hung jury and you don't get a decision. Whereas in this case, in the US, it was a unanimous verdict. And let's not forget that they didn't find 100% in favor of Johnny Depp. They did say that the one article from his lawyers, because it was so detailed, was defamatory in nature, and they did award, the jury that is, did award Amber Heard $2 million just for that one piece. So that was fairly significant. So it wasn't an absolute clean sweep for Johnny Depp. Although on his claims, yes it was, but they did find one in favour of Amber Heard. So ultimately, I am in support of jury trials. I do believe it removes any kind of inference or implications or speculations of bias, because not one person will be able to upset the entire decision. And just as a side note, if you missed it from my previous video, there is a provision, albeit not really exercised often in the UK, for defamation trials to be heard by a jury. The default position is that it's not heard by a jury under Section 11 of the Defamation Act 2013. I humbly suggest it should have been. Let's listen on.
Yeah, but she's a celebrity too.
Right.
But you have to remember, it's a tale of two trials. All the evidence came in the UK.
Pausing there. For all the reasons I've said, that is absolutely not true. And it's not true by the admission of the judge himself, who refused the application for permission to have third-party disclosure from Amber Heard. And Johnny Depp's lawyers were complaining all the way through the trial, paraphrasing the judge, that it wasn't fair for Johnny Depp because he didn't have disclosure, because the judge refused permission. So that statement by Elaine there, with respect, is completely false.
Mr. Depp brought that one. The burden of proof was on the son in the UK, because they had called him a wife beater and talked about the domestic violence. He had his opportunity to tell the truth then.
Pausing there, that's absolutely correct, because the burden to prove that it was true or substantially true, which is the reason I've paused the video to talk to you about it, was on the Sun, or rather News Group, Newspapers Limited and Dan Wootton as the two defendants, but it wasn't to prove, as this interview suggests, to prove that it was 100% true. That isn't accurate either. The law in the United Kingdom has a codified defence within the Defamation Act of 2013 that for the defendant to prove that the statements were substantially true, not 100% true. And as it happens, my personal view is I don't agree that they were substantially true anyway. And I come to that conclusion largely because I have issues with the judgment in the UK, and more importantly, we've now had what I consider to be a full trial in the US, a jury which I consider to be impartial. I do not believe that the jury would be biased in one way or another. I believe the jury came to a full and reasoned decision to themselves, which will only ever be known to themselves unless any of them speak out. But nonetheless, they heard the evidence and they gave their decision. Let's listen on.
And a 3-week trial, he lost. The judge found 12 acts of domestic violence, including sexual violence. And that came out November 2, 2020. We weren't allowed to tell the jury that.
Well, it's a different system, and the judge, it wasn't a jury, it was a judge. The judge said it was substantially true, and that is significant, and I think surprised a lot of legal analysts.
And just pausing there, those comments, absolutely right. It has surprised a lot of legal experts, myself included, and it is significant difference, as I just said, that it's substantially true, not 100% true. But as I said, I disagree with that anyway, but let's listen on.
But, you know, in this case, the jury not only didn't believe Amber Heard, but in ruling that she acted with actual malice, that means she had the intent to cause harm, right? That's a pretty high standard to have proven.
Just pausing there, this, I think, is a fundamental and crucial point, and a difference between the US trial and the UK trial. If there's a difference to be born between the two of them, this is it. Because in the US, for those that don't know in the UK, and even for those in the US that might not know, I've learned this in the process of researching these videos, but in the US, to prove defamation, you have to prove actual malice. So you've got to prove in the US that these articles were produced with malice, with the intent of causing harm to the reputation of the other party. In the UK, it's just to prove that the gist of what was said was true, not 100% true. So it's a very different test and standard of proof. And let's not forget that in the US trial, once again, it was decided by a jury. So not only was it a higher bar, in my view, but you had to convince an entire jury of the same thing to come to a unanimous verdict, which they did. Let's listen on.
And it's pretty amazing since the op-ed never even mentioned Mr. Depp.
This I didn't mention in my video, but I thought I'd mention it now. I think it was quite obvious that it was about Johnny Depp. I don't think anybody was in any confusion about that.
You have to remember that. What they learned from the UK case is to demonize Amber, which is what they did.
Now, just pausing there's a contradiction in terms there. Now, if you go back just a few seconds, she said that they weren't allowed to tell the jury about the UK case, but she knows that they knew about the UK case. What they learned from the UK case was to demonize Amber. Now, they wouldn't have been doing that if Elaine didn't really believe that they knew about the UK case. Now, some people will say that Elaine means the lawyers were demonizing Amber and not the jury. But listen to what she says later in the interview to confirm that she believes that the jury went away to research this case, which means it's really the jury she's referring to, the jury that researched it and the jury that learned to demonize Amber. Listen to this that she says later on in the interview.
And I have to believe that the jury, even though they're told not to go and look at anything, they have weekends, they have families, they have social media.
They were not sequestered. They were not sequestered.
And the 10-day period we had, how could they not?
If Elaine believes that they went away and researched it, as she said earlier in the interview, because they go home and they've got friends and they've got family, they've got weekends, then sure enough, if she believes that, then she must believe, in my opinion, that they also know about the UK case. And that statement confirms it, because what she says is, they learned from the UK case to demonize Amber. Now, I don't agree with that statement, but as you can see, it's a contradiction in terms.
Press as much of the evidence that came in the UK and did not come in the United States. But the other problem is we had cameras in the courtroom.
And then she goes on to talk about cameras in the courtroom and all this sort of stuff. But let's not forget that she is also an actor. She's used to being in front of cameras. I'm not for one moment downplaying that if someone is talking about domestic abuse and violence, that it's in front of a camera, then it's difficult. Of course it is. But it's just that the jury didn't believe her. And so all of these taken together, I just think this is damage control by Elaine. I think she's trying to pull reasons out for why the decision is wrong. I think she'd be far better either not saying anything at all, or just to go with the neutral aspect and just to say, do you know what, we did everything we could, but the jury decided this. And just for what it's worth, if the jury came back and unanimously found against Johnny Depp, these videos of mine would take a different turn, and it would be that the UK judgment was right all along, the jury have supported it, and all of the evidence that's come forward, you've now had 2 trials, you've got a solid decision. But what we have now are 2 distinctly different decisions, different jurisdictions, different defendants. In one sense, it's difficult to compare the 2, but I suggest that because the subject matter of both of them was the relationship and the alleged violence of Johnny Depp against Amber Heard, and what he says was violence against him, the subject matter was the same. I think the only fair way to have had this trial in the UK, this is my personal opinion, I think the only fair way to have had this trial in the UK would be to have had a jury and to have made Amber Heard liable to the full extent of the disclosure obligations, the same as it was for the defendants in the UK trial. Those are my thoughts as a UK barrister, for what it's worth. For those of you that are not familiar, I am a practicing barrister in England and Wales. I say UK for search engine reasons, but I've also put a link to my petition in the description below because I feel that with enough signatures, the courts in the UK can make an order of its own motion to reopen the appeal in the UK. It's very rare, it's very narrow, it's a very high bar, but that will obviously depend on a lot of signatures and a lot of people saying that it should take a close look at this. So I thank you all for your patience. Please take the time to like this video, subscribe if you haven't already done so, share it with somebody, and of course check out that petition in the description below. I will create a playlist of all of these because there's so much to talk about, and if you want me to, as in this video, by popular demand, I will keep talking about it. So thank you for your time, thank you for your patience, thank you for following me. I really appreciate it, and as always, thank you for watching.